Good afternoon. You can be seated. The matter before the court this afternoon is State Tax Assessor versus Fifth Generation, Inc. This is Kennebec 24490. We are being streamed live both by audio and by video. If counsel would identify yourselves by saying your names for the record together with the party you represent.
Daniel Murphy for Fifth Generation, Inc., Your Honor.
Thomas Moulton for the State Tax Assessor.
Thank you, counsel. And Attorney Murphy, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. May it please the court, this appeal requires the law court to address a federal statute, 15 U.S.C. 381, also called PL 86272, which prohibits states from imposing state income tax or similar taxes on foreign entities based on certain in-state business activities. Those in-state business activities are the following: the solicitation of orders for tangible goods, where the orders are sent out of state for approval or rejection, and the goods are filled by shipment or delivery from a point out of state. Fifth Generation, Inc., which manufactures and sells Tito's vodka to Maine's Bablow, meets these standards under Section 381. The term solicitation of orders is not defined in Section 381, but the Supreme Court in a 1992 case, Wisconsin v. Wrigley, defined the term expansively. First, the Supreme Court held that the term solicitation of orders provides a state income tax shield not only for actual requests for orders, but also any speech or conduct that implicitly invites an order. Importantly, in Wrigley, the court also held that solicitation of orders includes activities that are entirely ancillary to requests for purchases, meaning activities that serve no independent business function apart from their connection to the soliciting of orders. This is at page 228 of the Wrigley case. How do these concepts relate to this appeal? Fifth Generation sells vodka to Bablow, the sole importer and sole wholesaler of spirits in the state of Maine. The state tax assessor has retroactively assessed pass-through withholding tax against Fifth Generation for 2011 to 2017. The basis for the assessment was that Fifth Generation is required by Bablow to store spirits in the state bailment warehouse in Kennebec County, and Bablow requires delayed transfer of title until Bablow puts the spirits on a truck for delivery to a retailer. On this basis, the state tax assessor argues that Fifth Generation is storing inventory in Maine and selling vodka in Maine as if it has a storefront and as if it has a warehouse. The Superior Court granted summary judgment to the state tax assessor on these two issues, but it erred because it did not squarely address the issue of whether the business activities were entirely ancillary to the solicitation of orders, part of the entire process for soliciting and filling an order under Wrigley. Requiring storage in Maine and requiring delayed transfer of title are mandated by Bablow. In Wrigley terms, there is no independent business function or legal ability for Fifth Generation to do these apart from their connection to the soliciting of orders, which is the language from Wrigley. These are protected activities under PL 86272. In support of the trial court's determination, the court relied on a 1972 case called Hubline, which found that the requirements of South Carolina's alcohol regulatory scheme could result in income tax nexus and otherwise were not solicitation under 15 U.S.C. 381. Hubline was decided before the 1992 case Wrigley, which affords protection for business activities that are entirely ancillary to solicitation.
If you put aside Wrigley, and I know we won't, but I'm just starting there with Hubline, what is the difference between Hubline and this case? In other words, would you concede that under Hubline alone, the decision below would be affirmed? But I also understand that you're arguing that Wrigley may clarify, if not modify that.
Thank you, Your Honor. I believe that Hubline is very distinguishable. And if you look at the nexus in Hubline, at a time when solicitation at that time in 1972 meant just requesting orders, the High Court said these aren't requesting orders. And by the way, there's sufficient nexus. And if you look at the factual nexus in Hubline, you have an employee for Hubline, a Connecticut company that is employed in South Carolina.
But also compelled, right, under the control laws in South Carolina?
Yes, compelled. but literally present. We don't have anybody in Maine. We don't have an
So
office
if
in Maine.
instead of requiring, if Maine, instead of requiring the bailment warehouse arrangement said, and by the way, you must have somebody here, you would have to pay. That would be okay under Hubline, and you would have to pay.
Well, I do believe that Hubline is modified by Wrigley because solicitation of orders.
That's why I was saying, putting aside to the extent to which Wrigley, and I understand that there's an argument there.
Well, and it was the state board that found that the facts were unlike Hubline, and for those reasons, they seem to say that all you have, as a matter of fact, once you come into the state of Maine, is bare legal title, because and they said you can't reacquire the product or redirect it to another purchaser. All you can do, it only has bare legal title. Is there any case law that talks about whether bare legal title is enough in order to get the nexus?
Well, I did cite I think in-state presence also is what we're talking about, in-state presence, not just a connection to the state, but an in-state presence. And even then, under Rule 808, there are protected activities. But I did cite to the UCC 2401 that talks about the time of sale.
Yeah, but that comes into play only when there's no other arrangement. I mean, obviously, in contractual arrangements, parties can contract to have title passed differently. I mean, the UCC
We have no
supplies
contract with Bablo.
Well, but the UCC supplies a rule when there's nothing else in place, right? Of when title passes.
Those are default rules, but they are rules that apply. We have no contract with Bablo, and we've had shipments of spirits to Maine since 2011.
So let's assume in the bailment warehouse, a bottle gets broken. Who loses that bottle, you or someone else?
I assume that the state. I assume the state. Once we ship the spirits, we never see them again.
Well, I understand.
And we have no obligation
I understand you
to-
say you never see them again, although there may be some question about that. But if it's like, oops, not a full case, you're saying the state would pay for that? They'd pay you the full price even though it's not a full case? Because they haven't paid yet once you've put it in the warehouse, right?
So the continuous orders, the arrangement is a continuous supply of 30 to 60 days that's mandated by Bablo.
Mm-hmm.
And as far as if there's a case that's incomplete, if there's a missing bottle or something like that, I assume that the state would only pay for what it receives.
Right.
And
They don't pay before it's shipped, they pay after. The purchase order, the monies are,
Yes,
as I understand
yes,
it.
the purchase
The
order-
cases are shipped sort of based on a formula that says this is how much we think we need. And then they're held for however many days, and at some point go out to the retailer, and that's when the purchase order goes and you bill the state and are paid.
Yes, I mean, purchase order is a term that's used loosely.
I
because
understand
It
that.
reflects the continuous supply of spirits. And if we fall below those mandated amounts of 30 to 60 days, we get penalized. We lose
But I
the
think I hear
ability.
you saying that if a case, is incomplete or if it breaks or something like that, you won't get paid for it.
Well, those are different things. If it's incomplete, the state's not going to pay what it didn't receive. If it's broken, actually, under the Pine State and NBC contract, it's Pine State's
So
problem.
there is a contract.
With Pine State and
Yeah.
the state of Maine.
Yeah?
We're not a
There's
party to that
casualty
contract.
loss.
What's that?
If the product is destroyed somehow, is there casualty coverage for it for which you would recover?
Not that I'm aware of.
And that's because of your contract, though, with Pine State.
We don't have a contract with Pine State. It's the state of Maine and Pine State that have the contract. Pine State, as the agent of the state, assumes the risk of loss for the inventory until it gets on the truck going to the retailer.
But just following up on Justice Lawrence's question, if the warehouse burns down before any of that product is moved on to the retailers, and let's put aside any insurance, who bears the loss? Is it your client or is it the state of Maine?
From our perspective, it'd be the state of Maine.
On what basis?
From the course of dealing we've had from 2011, it's also reflected in the UCC 2401 that regardless of the timing of transfer of title, that when you deliver to the point of delivery, your performance is done, that it's delivered. But also under that contract between the state of Maine and Pine State bears the responsibility for the inventory.
You mentioned earlier the phrase in-state presence.
Yes.
Is the employee in the Hubline case an example of in-state presence?
Yes, yes.
And so if your client contracted with an agent, not an employee, but you had a contracted agent in this state, would that constitute an in-state presence?
It depends. It depends. Pine State is the agent of the state of Maine, not the agent of Fifth Generation.
Understood, but doesn't the record reflect that your client had a contract with someone? Was it with a ski tour outfit or?
So all spirit suppliers have to have a licensed broker. It's required by BABLO. And we have MS Walker as our licensed broker.
Walker, right.
It's an independent contractor, and that has special protection under Section 381C. But MS Walker has dozens of brands that it represents. It's not just simply us. And what they do, it's protected activity. It's missionary sales activity under Section 381, subsection 2. They extol the virtues of the product, they advertise, they solicit sales, and other protected activity.
So what are we to do with, you've argued that compelled storage and delayed transfer of title are really ancillary to the solicitation of orders, right?
Yes, Your Honor.
But Wrigley also made clear that it's not enough that activity facilitates sales, it must facilitate the requesting of sales. And when you talk about the compelled storage or delayed transfer of title, isn't that potentially, if it's ancillary to anything, it's ancillary to the sale itself, not to the solicitation of sales?
No, I think that you have to look at that phrase from Wrigley, facilitating sales versus facilitating requests for sales in context. And there the court was looking at...
I think I am, actually. I read it.
Well, the court was looking at the practice of replacing stale gum. This is for the Wrigley Chewing Gum Company. And that activity is something that Wrigley wanted to do, but it's not something that's going to generate a new sale. You're replacing gum that has already been sold.
But isn't that true here as well? In other words, the placement of the bottles in the cases in the bailment warehouse doesn't solicit new sales. It is facilitating sales, essentially, that are already happening.
To facilitate solicitation, we must comply with the requirements of BABLO. Even in the summary judgment record, the state tax assessor has admitted that these are required. If you want to sell spirits in Maine, you have to...
I understand it's compelled. The question is whether it's really facilitating the solicitation of sales or the sale itself, and the red light is on. So we'll come back to that.
The answer to
I'm
that
sure.
question is yes, Your Honor. Thank you, Your Honor.
Attorney Knowlton.
Good afternoon, Chief Justice Stanfield. May it please the court. Deputy Attorney General Thomas Knowlton for the State Tax Assessor. There's no dispute on this summary judgment record that during each year, Fifth Generation stored substantial amounts of its vodka at a bailment warehouse in Kennebec County and sold its vodka to the state in the state of Maine. Those undisputed facts foreclose its Public Law 86-272 argument under both Wrigley and Hubline. Wrigley said that sales, in-state sales, are, as a matter of law, not protected. And Public Law 86-272 doesn't protect storage within the state either, because those are not requests for purchases or activity that is ancillary to requests for purchases. Storing your product in a state has nothing to do with the solicitation of orders. The court should affirm the Superior Court decision upholding Maine Revenue Service's assessment. Fifth Generation and its shareholders do not have a constitutional or statutory right to do business in Maine, sell millions of dollars of Tito's vodka in Maine without paying their fair share of Maine taxes, just as other businesses with Maine nexus selling their goods in Maine are required to do. A couple of rebuttal points before I take the court's questions. It's not a matter of just bare title that fifth generation has. Under paragraphs 26 and 27 of our Statement of Material Facts, it is undisputed that fifth generation, and like all suppliers, had the ability and right to access and retrieve their spirits when they were stored in the bailment warehouse. In paragraph 27, M.S. Walker, that was a fifth generation's broker, testified that it in fact regularly retrieved bottles of fifth generation's spirits from the bailment warehouse from 2012 to 2017. A minor point about licensure, M.S. Walker was not, I'm not sure it's material to anything, but M.S. Walker was not licensed by Bablo. Bablo licenses humans, individual brokers, not entities. And I'm not sure it bears on anything that's material to the legal arguments, but to the extent that fifth generation repeats that M.S. Walker was a licensed broker, it was not. It was a broker for 2 to 3 dozen brands, but it was not licensed by Bablo. I'm happy to answer the court's questions.
So on your issue about how it's more legal than legal title, I'm looking at the appendix, page 46, and the board found that once located at the warehouse, the product was outside the company's possession and control, although the company retained bare legal title to it. The product was committed to sale to the state, and the company was unable to require the product or redirect it to another purchaser. Are you saying that the record, summary judgment record, shows that those factual statements are wrong?
The board was wrong. The board was completely wrong.
Factually?
Correct. And it's a de novo appeal, so whatever the board decided is not
There's a new
pertinent.
record, it's
Correct. The summary judgment record establishes that, in fact, all suppliers, including fifth generation, had the ability and right to access their spirits while they were stored at the bailment warehouse.
So there's no factual dispute over that?
There is testimony from M.S. Walker and Greg Mineo from Bablo on this point. Actually, Mr. Mineo, the former director of Bablo, said that's why it's a bailment warehouse, because it's their spirits.
Well, it's got to be, so there's no evidence on the other side either, right? It's not a disputed fact.
The evidence is that fifth generation says that it, in fact, did not retrieve any bottles. That they themselves, their employees, did not retrieve any bottles during the audit period. That does not contradict or even contravene the notion that all suppliers, the testimony that all suppliers had the right to do so, and that in fact M.S. Walker, who was the broker for fifth generation, regularly retrieved bottles of Tito's vodka from the bailment warehouse during the audit period, from 2012 to 2007, during the time, from 2012 to 2017, during the time period when M.S. Walker was fifth generation's broker.
Would it be fair to infer that Maine's three-tiered system was configured in a way intentionally to avoid 86272?
There's not, they don't even argue that, Your Honor. There's no suggestion of that. Maine's had a
That's a fact.
three-tiered system for a long time, and it serves legitimate governmental purposes. It makes money for Bablo. It's a money-making venture, and it helps facilitate the distribution of spirits throughout the state.
I was just about to get to serves a valid state
Correct.
purpose, but I guess you hit that point.
Yeah, it was not done to try to force out-of-state suppliers to have nexus. It was done for Title 28A governmental purposes related to liquor in Maine, not taxes. With respect to Wrigley, which did come 20 years after Hubline, Wrigley cites Hubline several times neutrally, if not positively. It doesn't undercut Hubline in any way other than the Wrigley court came up with a general test for interpreting what solicitation of orders means in Public Law 86-272.
Are cases involving liquor sales, which are so heavily regulated by the state, different than private retail goods like Wrigley gum?
They're different to the extent that when states, what Ublind says is and it really doesn't change this, when states decide to regulate the sale of spirits like South Carolina did or like Maine does, and the result is that if a supplier decides it wants to do business in that state, it's going to end up engaging in activities that take it beyond the protection of Public Law 86-272, and the Supreme Court in Ublind said that is totally fine. That is permissible. 86-272 does not prohibit that.
So if we adopt the position that title remains in fifth generation until it's actually sold to the wholesaler, do we need to address the 86-272 concerns about solicitations of orders or solicitations of orders to benefit a customer? Do we even have to look at that analysis, or does the fact that title exchanges at the time of that sale ices the whole issue right there?
I think the court needs to address the 86-272 argument, which is that it only protects requests for purchases and activities that are entirely ancillary to that, and storage is not, and selling your product within the state is not.
So we don't even have to dabble in the definitions involved in 86-272?
It's very
To say
clear
that
under
it doesn't-
Wrigley.
We have to address it, that's the issue.
Yes.
But we can simply say, from your perspective, it simply doesn't fall under that exemption.
Correct. And there are other undisputed facts that really cement the idea that this is the supplier's spirits. The way the purchase orders and the invoicing is done, the purchase orders aren't submitted by the state, and fifth generation didn't invoice the state until after the spirits were removed from the bailment warehouse. All suppliers, including fifth generation, had to pay bailment fees to store their spirits at the bailment warehouse during the audit period. And M.S. Walker, who was and is a broker for 2 to 3 dozen brands, testified in his deposition, which is supporting paragraph 22 in our statement of facts. M.S. Walker testified that suppliers own their spirits when it's stored in the bailment warehouse. So when you put all of the undisputed facts together, along with, from March of 2014 forward, the statute in section 83-C of Title 28A, which expressly provides that spirits are owned by the suppliers until they're removed from the bailment warehouse. There is no legal dispute or factual dispute about who owned the spirits while they were stored in the bailment warehouse.
What they're really arguing is, if I understand it right, and I'm sure Mr. Murphy will correct me if I'm wrong, that the state can't compel a foreign seller to engage in activity, in other words, the bailment, if it wants to solicit orders, and then use the same activity to subject them to taxation, for income taxation.
Well, the state is not compelling fifth generation to do anything. Fifth generation wants to.
If it wants to solicit orders in the state.
If all they were doing was soliciting orders within the state, then they would be protected. That is not all they're doing.
That's not my question. If all they want to do, putting aside what maybe they are doing, okay? But in general, if all they want to do is solicit orders in the state, doesn't the state compel them to maintain the bailment, to have the sales here, maintain the bailment arrangement, have them shipped to the bailment warehouse, just as they did here?
If fifth generation or any supplier wants to do business in Maine, it needs to comply with Maine law.
So,
and one of the laws is that they have to store their spirits at the bailment warehouse.
so in other words, it is impossible, is what you're saying, for a seller of spirits to sell any spirits in Maine without being subjected to the tax here.
that they need to comply with Maine law, and one of the requirements of Maine law, Your Honor, is that they store their spirits at the bailment
It is
warehouse.
impossible to solicit orders in this state without being compelled to also pay income tax.
Storage has nothing to do with solicitation. They can solicit all they want, and that will be protected. The issue is that they're not engaged only in solicitation within the state.
So they can't sell in the state without being
They're making
subjected
sales in the
to
state.
tax.
There are also additional activities that the Superior Court didn't address, one of which is that
You
on a
really don't
regular
wanna
basis, they
have
were
focus on that, do you?
they were asking Bablo to put their product on sale for that's a good business strategy. Again, this is a good business. They made a ton of money during the audit
Well,
period.
I'm looking at
But-
your point where you're saying that it's undisputed that there is no indicia of ownership, that it all remains with fifth generation. And I'm looking at paragraph 18 at the appendix 214. There was a qualified response and lots of record citations where they're objecting to your position that their ownership didn't effectively go away once they hit the warehouse. Are you saying that if I look at every single one of these record citations, it will be revealed that it is undisputed that there's more than bare legal title?
There are no genuine issues as to the material facts that we set forth in our statements, yes, Your Honor. There are plenty of objections in their Rule 56H2 statement, and plenty of qualifiers, and plenty of citations, but they do not contradict the facts that the assessor put in his statement of material facts.
You had listed in your, or you had made the argument below to the board that there were a number of nexus-creating activities, and chief among them were storing product in Maine and transferring and selling the product in Maine. But then you listed a bunch of other, or made a number of other points, which is that MS Walker did a number of things for you, like hosting parties or requesting special pricing or changing planograms in stores. Those all struck me as ancillary to solicitation.
Ron, asking that your product be put on sale has absolutely nothing to do with soliciting sales. It's something that happens typically after the buyer has already purchased the product, and you're trying to make a good business decision and undercut your competition by selling your product at a smaller price, a lesser price.
Organizing a VIP party or forming a partnership with the World Pro Ski Tour, those are not related to soliciting?
No, Your Honor.
Aren't they, they're related to creating a bigger market, aren't they?
They're designed
Promoting
to
the product.
They're designed to increase the sales in Maine, but facilitating sales or facilitating purchases isn't sufficient under Ridley. You have to
Soliciting sales is what the statute says,
It
correct?
has to facilitate the requesting of sales. It has to be functionally connected to the solicitation process, the requesting that somebody buy your goods. And putting your stuff on sale is not connected functionally or otherwise to asking someone to purchase your goods.
In this case, fifth generation raised a legal challenge to this process and cited authorities and so on. Would that qualify them for a waiver or abatement of the penalties, this good faith challenge?
No, Your Honor, they didn't cite any case that provided any sort of authority for their position here. Their argument, may I finish?
May.
Their argument on why they shouldn't be, why the penalties should be abated was that Maine Revenue Services lacked personal knowledge of the bailment system and the details of the transactions, and that's not.
I don't think that's really, I mean, they really were saying they made at least an argument. If they were to lose, they nonetheless had essentially a good argument, and that permits the abatement.
They haven't made an argument that amounts to reasonable cause, and didn't below.
Thank you.
Thank you, Your Honor.
Attorney Murphy? I think you
Thank you,
reserved,
Your Honor.
what, 3 minutes for rebuttal?
Briefly, the court addressed missionary sales activities. I want to note that the trial court did not address that in any way whatsoever. So there's no trial court decision one way or the other whether there's a disputed issue of material fact. It's just set aside. This is a very narrow appeal on these two issues.
Well, what's your response to the position of the state that There's lots more here than bare legal title.
Let's have a trial.
Well, I mean, how did you dispute it? Where's the evidence that there is lots more?
I mean, what they're saying
Or
is that
not.
you have the right to retrieve and access the spirits, even if, whether you chose to do so or not,
Well,
is a different thing.
Mr. Knowlton mentioned paragraph 29 of the State Material Facts, where he said that FGI, Fifth Generation Inc., regularly accessed bottles and bailment. That's totally factually incorrect. And in our opposing State Material Facts, we addressed with citations why it was incorrect. We've never done so. We've never been in the state of Maine grabbing bottles from the warehouse.
Isn't the
He
question
said
whether you have
MS
the right
Walker
to do
did.
so?
He said MS Walker
This-
did.
MS Walker, there was some testimony, and then you'll see in our objections and also denials, the MS Walker representatives said that I'm just speculating. You know, we have 30 or 40. I may have grabbed a bottle once in the last 8 years for samples.
But they could have. They had the right to.
An inchoate right for a company that resides in Texas is not an in-state presence in the state of Maine grabbing bottles in Kennebec County. Income tax,
Well, if you've actually grabbed the bottle, it's not inchoate.
no, the right's inchoate. The right to grab a bottle. Our understanding,
But I thought you said that there, rare occasion, but you did say that
MS Walker,
had.
MS Walker, an independent contractor, represents dozens of different brands, has visited the warehouse.
But
and
if they grabbed a bottle of Tito's handmade vodka, they weren't doing it in the representation of another brand, they were doing it in the representation of Fifth Generation.
It was not, if it happened, if you look at my citations, the testimony from these witnesses from MS Walker actually said, I'm just speculating, I'm just guessing, I could have grabbed the bottle for samples. It's very, very speculatory. And so.
But they couldn't have done it except under title from Fifth Generation. They would have no right to take it except under that
They represent
relationship.
dozens of suppliers. They can go to the, have
They
entry
can
somehow.
grab anybody's product?
Well, somehow the licensed brokers have access to go to the bailment warehouse, and one person said, I could have grabbed a bottle during the past 8 years. That is de minimis, but also I think that's, if you look at State Material Fact 27, what it says is that Fifth Generation grabbed bottles regularly. That's incorrect. But the objections that we had were ignored. The denials that we had were ignored. There is a contested fact issue to try here. With respect to protected activity that's in state, if you look at page 12 of our reply brief, in bold, these are the activities that are protected, in-state activities that are protected. And so I know that the state tax assessor is saying there's more here, but as far as these missionary sales activities, they haven't even been addressed by the trial court whatsoever. We'd like to have that trial. We'd like to have our due.
Thank you.
Thank you, Your Honor.
Thank you, counsel, for the argument here today. As is our usual practice, we'll take the matter under advisement and issue a written decision. And with that, I believe we're in recess for the day.
All rise. All persons having any further dispute with the Honorable Court, sitting as a law court, may depart and give their opinions and sound place roll. Mr. Paul, the Chief Justice, this court now stands adjourned. God save the name and this honorable court. Is it after? I don't hear anything either. Testing 1, 2, 3, 4. Yeah.
Okay.
Yes.
Good afternoon, everyone. I think we're going to proceed. Welcome. I'm Chief Justice Stanfill. Thank you for coming to this very special recognition event in honor of Nancy Rabasca. I think the fact that so many people are here squeezing into this courtroom on this, what I understand is a lovely day outside, speaks volumes in and of itself. I'm not going to take any of your time right now. Nancy was very special to the Supreme Judicial Court and all who have worked with us. But I think we have some wonderful speakers here today and a master of ceremonies to whom I'm going to turn it over, who will tell you a whole lot more. So I'm going to call on retired Justice Ellen Gorman.
Good afternoon. First of all, I want to recognize the members of Nancy's family who are here, her brother, Stephen Rabasca, her sister-in-law, Christy Rabasca, and her sister, Diane Rabasca. Would you please stand and receive our thanks for being here? So as you know, Nancy would not have wanted us to make a fuss. Nonetheless, we are going to. So we're going to hear from Judge Lopez, from Justice Alexander. We're going to hear from Matt Garrity, who is currently the Chief's law clerk, who's going to be speaking on behalf of the hundreds of law clerks that Nancy somehow got through their clerkly years. We're going to hear from Matt Pollack, who collaborated with her on all kinds of programs and projects, and also talked to her librarian to librarian for hundreds of hours. We're going to be hearing from Julia Sheridan, who is the secretary of the Cleaves Board. And we're also going to be hearing from Derek Langhauser, who knew her in a more personal way. And we're going to hear a lot about Nancy today because we all knew her in a professional way, but also loved her in a personal way. And I'm not going to take any more of your time by telling you any stories about Nancy, because you all have your own stories, and I just want us to get on with the day. So we're going to start by hearing from Judge Lopez. I'll warn you ahead of time. I told each of them that they had about 10 minutes. So I'll let you know which one of them followed my direction and which one did not. Judge Lopez.
The hardest part was getting here. And please don't worry about this binder. People see a binder and they say, uh-oh. I can assure you I'm going to faithfully observe the time limits. Justice Gorman, ladies and gentlemen, good afternoon. It is a privilege to be here today to participate in this memorial tribute to Nancy Rabasca. When we heard that Nancy had passed away unexpectedly on August 5th, there was the shock and sadness that inevitably come with such news. Then, for those of us who had worked with Nancy over the years, these emotions were followed by memories of those interactions, most of them involving requests for help. In my case, the requests ran the gamut. Nancy, could you please find the title of a book, the draft of a bill, some legislative history, the commentary on a bar rule, accompanied, as usual, by my unhelpful descriptions. Of course, her assistance was always forthcoming, sometimes preceded by an apologetic note, such as, and I quote, "I will try to call you tomorrow. As usual, today I got pulled into a large research project." How often that must have happened to Nancy, trying to help one person, only to be pulled in another direction by a person with a larger, more urgent request. Over the years, there were surely thousands of such requests, probably from many of you here today. Unfailingly, with good cheer, Nancy did her best to respond. I had one interaction with Nancy that involved much more than a specific request for help. In 2009, when I was chair of the Maine State Federal Judicial Council, we decided to create a video about the lives and work of Maine judges that could be used in Maine's high schools to enhance the understanding of students about the role of the judiciary in our society. Nancy was the indispensable force in making this project happen. She helped organize many of the video interviews with judges that provided the material for our project. Then she became the project's producer, director, camerawoman, editor, prompter, critic, and guiding spirit. In the end, thanks largely to her tireless efforts, we created an excellent educational video about the judiciary that would be used in Maine schools for years to come. On August 1, 2011, in the midst of this collaboration on the judicial education video, Cleaves celebrated its 200th anniversary. This anniversary required a special celebration. Cleaves is the third oldest law library in the country, surpassed only by law libraries in Philadelphia and Boston. It is 9 years older than the state of Maine itself. As early as 2000, my good friend Estelle Lavoie, a member of the Cleaves Board of Directors, urged the board to start planning for the bicentennial celebration. It did, creating a 200th anniversary committee on which Nancy, of course, served, one more hat for her to wear. The committee's careful planning and Nancy's hard work culminated in a remarkable event, a luncheon at the Eastland Hotel, as it was then called, with Chief Justice John Roberts as the featured speaker. Unknown to Nancy, as part of the planning for the event, Estelle had been engaged in what she described as, and I again quote, a deep covert operation. As I think you can tell, Estelle had a long career in politics before she turned to the practice of law. In any event, a deep covert operation to honor Nancy at the luncheon. As part of that operation, Estelle asked me to write a letter to Nancy acknowledging her singular service to the legal community. I would like to read a short portion of that letter now. Dear Nancy, on the occasion of celebrating the 200th anniversary of Cleaves Law Library, I want to thank you for your 24 years of distinguished service to the library and to our legal community generally. If the phrase unsung hero has a poster woman, you are it. Now it is time to sing your praises. I then continued in the letter, for myself and for so many others in this legal community, Cleaves has been an indispensable institution. As a young lawyer in Portland with a solo practice and no library, Cleaves was my life support. I spent innumerable hours there doing legal research and asking far too many questions of your predecessor and dear friend, Ann Pierce. In later years, when you were there to answer my questions, Cleaves became a quiet place to go to read law, get away from telephones, see old friends, and converse quietly. Cleaves is more than just a resource. It is also a communal experience. Rereading the words of that letter today, I am struck by how accurate they remain in describing Nancy's tireless service to the library and our legal community in the 14 years since that bicentennial celebration. To say the least, Nancy did not rest on her laurels. She knew that Cleaves Law Library was a priceless treasure for our legal community. She was the perfect custodian of that treasure, preserving its accessibility and communal quality. Nancy loved her work. She enriched us all with her skills, intelligence, energy, and generous spirit. She is irreplaceable. We mourn her loss. But today, we celebrate her immensely consequential life. Thank you very much. Thank you.
Good afternoon. I'm Don Alexander, former Justice of the Law Court. And I want to say right out, as I've known for many years, because I've worked with Kermit for many years, I cannot deliver with the same rhetoric he was able to give you and the same degree of history about Nancy. But I can hopefully speak to you with the same passion of respect and all, because I've worked with Nancy from the time Chief Justice McCusick sort of asked me to start looking at state law libraries and what we're going to do with them. And unfortunately, some of the answer what we're going to do with them, not Cleaves, but some of the others is we phased them out. But anyways, that was never an issue with Cleaves because of the size of the commitment we have and because of the skill and dedication of Nancy and the people that have preceded her. Because that's one thing that, you know, all of you have worked with her, and I bet most of you have, was the extraordinary dedication she had, the extraordinary, you know, humor she would give with it, always light, she was just such a wonderful person, giving all to us. I just emphasize to the family that this is a unique person, absolutely dedicated, always looking out for what's the best of us, even if, you know, she had to overwork or things like that. As Kermit Lopez pointed out, often a lot of us gave her projects because there wasn't any sort of priority list. It was just something that would come in and go to her and help out. And as a result of all of that, all of us, judges, lawyers, members of the public, were much better off. Our work was much better, not because of any great skill of ours a lot of times, but because of Nancy's skill, dedication, and absolute wanting to do the best we could every single time. And that was extraordinary. It was a lot of work because just running the library and, you know, tasks became tough sometimes. Running the library includes, you know, checking out books, checking them back in, getting volumes of new books in, getting them on the shelves, getting them, you know, clicked in and cataloged. And, you know, all of that has to happen. But with Nancy, that only happened after the project she worked on. And the product of the project she worked on is not only in your good work and success, those of you who have used her, but also it can be seen in the library. Yes, we have a lot of books in the library, a lot of old books. We keep them. Nancy greatly valued keeping the collection, supporting it and all that. But one thing you see in the way back of the library is, you know, shelves and, you know, stacks of legislative research, a lot of it original, or a lot of it legislative documents that not too many people have and keep track of. You know, Senate Judiciary Committee report on changing the, you know, nature of the court or the district court or the Superior Court, or how we do family law from, you know, 1990 or 2002 or things like that. These are things she kept. Plus, she would make memos for people to, you know, support their research on legislative history and other things too. She would also cooperate with all of us on anything that we wanted to do and make it better, be it, you know, legal research or whatever. You come in and say, and a lot of you may have done this, gee, I need to do some work on the old rules and how the rules have changed, is there any way you think I could find a 1981 rules book? No problem. Here it is right in my office, right there. But, I mean, think how many of you have experienced that and immediately had therefore your work much easier than ever else, because all those books in the office, and yeah, they look kind of old, and what do we do with them? Well, they're all extraordinarily valuable for the once every 3 or 4 years that somebody needs them. And she kept all of that, the legislative history, the unique books in her office, the way she kept care of it. And, during her tenure, it basically expanded the whole range of legal research, or at least the way it's been done for the last, 200-300 years, something like that. When she started off, in the late 1980s, started off at Cleaves in the late 1980s, looking up the books meant going and getting the book and looking at it and things like that, finding the page, writing it down. Maybe you click something on it, but remember, we didn't have computers and word processing, into the 80s. I can remember one situation where we at least had these typewriters that retyped things new. But then I remember a situation too, this was shortly before Nancy came, where one opinion where this was the Superior Court, not the elite law court. This was the Superior Court. And opinions getting printed out, and it turned out it was going to be about an 80-page opinion, but at page 59, the printer burned up, literally. But that's when Nancy came in and started. And since then, we went to, beyond the books, we then went to having the court itself produce, an electronic opinion. That was a huge, dramatic change in how we did that. And that occurred for the Maine Supreme Judicial Court in 1997, from the first opinion from 1997 on. At the same time, we were moving into electronic legal research. And so, in addition to all the books, we had to get on computers, things like that. Nancy was right on top of that, and getting computers installed, and then, figuring out how to deal with the competing research programs, Lexis, Westlaw, things like that, and trying to keep them all up and paid for and supervised and things like that. It was a tremendous job, not something that you all recognize. You just come into the library and, okay, where's the computer? Can I use it? And the only time you get upset is, if it's not working right. And then you say, oh, geez, Nancy's not doing her job. No, she was desperately doing her job because she's doing all these research projects too. And it was just so wonderful, the transition she had. It was pointed out then that also during the early 2000s, she started on this thing of having she was the primary promoter of it, recording a whole lot of people. And all. And we still hope we're able to do that, recording, for, again, legal history. We've got to now work on getting those things cataloged and stuff like that, but we have tremendous recordings of people, plus the video she put out for the high school people that were talked about. Again, that's just extraordinary work she always done, and again, legal research becomes more complicated, but she's able to then tell us how to find things and things like that. One of the most important things, I think, too, is now we're moving from sort of electronic legal research, clickety-click, and you can write opinions about, I don't know, rule of perpetuity. I haven't heard about that recently, but or what's current today, the rule of law, what it is, what it's been, what it may be, and how we litigate it. But that's all important. Talking to Nancy about, one of the last couple of times I was in, it was 3 or 4 months ago now, we were talking about this and talking about AI and what happens. And she said, and I think it's true, that in her view, AI is going to make places like Cleaves more important, because we know that AI has some what should we call it, speculation or strangeness to it, sometimes just made up out of the blue. And the way to make sure, after you've done AI, after AI's written that 50-page brief, is, and this is Nancy's view, and it absolutely is my view too, is you've got to go back, you look at the secondary materials that are available, you know, the Maine secondary materials, or if it's a federal court, the federal secondary materials, or if it's New Hampshire, the New Hampshire secondary materials, just to see if you're reflecting the correct law, as long as we have the secondary materials kept up to date. And that's so important to do. And you can go back and check the opinions. Is this opinion that says just what you want to say, is it really in the reporters? Or is that something that just spouted out of AI? And she's right. If we want AI to work, we've got to have places like Cleaves, as Nancy envisioned it, available to be able to check that work before you finally submit it to the court or wherever else you may be submitting it to. But just, she was aware of that. She was on top of that. Say, yes, she's been around a while. Yes, she knew a lot of research and was a great, you know, of history. But she was, you know, forward-thinking and forward-working on the law too. That's just a great, tremendous service she did, almost inspiring to talk to her, and you get motivated you want to do a better job because of what Nancy did and because of the activity she had. And also, it's a tragedy she's gone. She was such a wonderful person. She did a great job for all of us and made a lot of us, you know, sort of think better and work better in our legal things. And just a great person. I tell her to her family and to all the rest of us, and a great, wonderful person to remember. And thank you for listening to me. It's a lot of things. Thank you.
Good afternoon. I'm going to do two things today that I never do when I speak publicly. The first is I'm going to speak personally, and the second is I'm going to read. The two are related, and I feel that I owe both to Nancy. Madam Chief Justice, members of the court, distinguished guests, thank you for convening us today to commemorate the distinct professional contributions of Nancy Rabasca and for inviting me to participate. My name is Derek Langhauser, and I'm an attorney who has practiced in Maine for 37 years. I am just one of countless attorneys who relied on Nancy during her 4 decades at the Cleaves Law Library. We all have our own experiences and remembrances of Nancy, and I am grateful for the privilege to share mine. My story starts in 1987, the year I passed the bar and started work, and this was fortuitously the same time that Nancy started at Cleaves. I first met Nancy when at the start of my clerkship with this court, Chief Justice McCusick walked all the clerks from his third-floor chambers over to Cleaves. Because it was Chief Justice McCusick, we were all intimidated, which is why I still recall the ease with which the chief confidently handed us off to the young librarian to teach us how to research to the court's high standards. Our session with Nancy was the centerpiece of our day in clerk camp, as then Associate Justice Wathen called it. But little did I know that those 90 minutes in Cleaves would be the first of 1,000 hours I would spend over the next 37 years working with Nancy in her office, in the reading room, among the stacks, and by email reviewing the inevitable troves of what she found. I have spent most of my career as a solo practitioner without partners, associates, or law clerks. As chief legal counsel to Governor Mills and McKernan, constitutional counsel to Senator Snow, and general counsel for Maine's community colleges and Maritime Academy, I've had broad subject matter practices and faced on a daily basis a wide range of issues. Nancy was long my most dependable colleague. Very early on, she taught me that no one should dabble in legislative history, or, we all know that, or prowl unsupervised through AMJUR, ALR, CJS, or the key number system, not to mention the Decennial Digest. No, you needed someone like Nancy, and she was always there to help me. For 37 years, we journeyed through the law together, striving for work that products that, in the words of the American Law Institute, clarified and simplified the law so that I could best translate its meaning and effects for my clients, so that for my institutional clients, I could find the best options for compliance, and so that for my executive clients, I could find the course that best met their duty to take care that the laws be faithfully executed. In practice, these assignments were easier said than done, but Nancy always answered the call. Not literally, of course, because I think we all know that Nancy never answered her phone. Just like she never had any place for you to sit when you stopped by her office. Unless, of course, you timed it just right so that the little red wooden step stool was by sheer fate at least partially empty on top. But no matter, whatever and whenever the question, Nancy got right to it. Her diligence and skill were for over 3 decades at the center of the informed basis that my clients and I needed to make decisions. I think examples best show Nancy's impact. During my clerkship with this court, it was Nancy's careful research of the history of the parental termination statute that contributed to a child being reunited with her father. During my first tour in the governor's office, Nancy carefully researched, for example, the federal law of cruise missile test flights, the constitutionality of our primary election minimum vote requirement, the power and limits of executive curtailment of financial allotments during revenue shortfalls, the federal preemption of a proposed state strikebreaker law, the presentation requirements for general fund bond obligation issues, and the power and limits of executive authority to operate state government when the prerequisite operating budget had not been enacted. For my college clients, Nancy's research informed our approaches to free speech on campus, firearm regulation, institutional and individual academic freedom, use of criminal conviction information in dorm placements, the legal distinctions between state instrumentality and state agencies, and the over 300 statutory exceptions to our freedom of access law. For Senator Snowe, Nancy's work informed the review standards for 4 nominations to the Supreme Court of the United States, efforts to constitutionally regulate campaign financing, and the history and nuances of the filibuster rule. It was Nancy's research on the history of U.S. Senate procedures that informed Senator Snowe's proposal on how to try the impeachment articles for President Clinton, a proposal that impressively earned unanimous support from a then deeply divided Senate. It was Nancy's side-by-side research of the federal military base closure statute with its 18,941 words spanning 38 pages that helped highlight the recent amendment that added just 2 words, surge capacity, that the senator and her colleagues from the Maine and New Hampshire delegations seized upon to save Portsmouth Naval Shipyard from closure and the severe employment and economic impacts the closure would have caused. And it was Nancy's creative research of, yeah, you'll hear this list right, federal cemetery, copyright, RICO statutes, and then 3 U.S. Supreme Court First Amendment cases that helped us create a novel statute that constitutionally effectively ended the disdainful organized protests and military funerals across the country. The final leg of our journey ran back through the governor's office. 30 years later, we returned to the usual array of issues that one can expect there. The first thing we noticed was that all of Nancy's research from 30 years before was still good law. Still, there were new challenges to meet. For example, Nancy's research contributed to the development of a statute that authorized the removal of firearms from certain persons in distress. Enacted with unprecedented bipartisan support, 134 to 9 in the House and 34 to nothing in the Senate, Nancy helped create a law that is among the most effective of its kind in the nation. Nancy's research contributed to our understanding of the scope and limits of the executive to administer its emergency responses to the pandemic, and to the successful defense of the dozens of lawsuits challenging the most prominent of our 94 executive orders thereon. And it was Nancy's research that helped lead to the historic posthumous pardon of a Maine attorney unjustly targeted for prosecution in 1969 simply because he had the temerity to advocate for tribal interests. Despite all this consequential work over all these many years, Nancy always wanted to remain invisible. But I made sure that my clients always knew who and how their counsel was being developed. And so I also made sure that when the tables were turned and Nancy was asking me for help, I would do my best to reciprocate. Nancy would ask me for help on matters relating to the management of the library itself, serving on and recruiting for her board, drafting bylaws, policies, and procedures, and addressing the issues of the day. Over the decades, we saw a wide variety of such issues, surprisingly broad for a small entity. The most memorable, I think, for both of us were addressing the two gentlemen who came in at separate times to use the reading room, one for brushing his dogs and the other for filleting his fish. More involved, though, was the day that Nancy asked me if we could memorialize some of our research into articles, and so that all that we had learned over the years would not simply be lost in the files of forgotten cases. And so I agreed, and I started to write, and Nancy kept the drafts accurate and complete. We got a little carried away. Since 1999, Nancy and I collaborated on 10 law review and journal articles, 1 compendium, and 1 book. There was a piece on Blackstone's commentaries that really excited Nancy because she could, at long last, use her age-old leather-bound set that was tucked away in the far corner of the office, often hidden from view when her door is open. There was a 2,100-page compendium of college campus free speech resources that we compiled with the former president of the University of Virginia and the former Solicitor General of the Commonwealth of Virginia, where Nancy helped identify and gather entries for use by college lawyers across the country. There was a 120-page book on the executive powers and duties distributed by the National Governors Association to every governor and governor's council in the nation, where Nancy helped source and correct many of the nearly 700 citations. But I think that Nancy would say that of all our collaborative efforts, she was most proud of the law review article entitled "A Tribute to Vincent L. McCusick." Reprinted 3 times, this piece traced the chief's extraordinary life, and Nancy dominated the research. She tracked down news clippings from the chief's earliest career moments and detailed every material statistic of his reported opinions. We even endured a 1-month delay while we debated why the Lexis and Westlaw statistics did not align, and which source was in fact correct. But it'd be no surprise to any of you that, true to form, it was Nancy who reconciled these differences by determining how each source was only partially correct and mostly incomplete. And when we were finally done, we presented the final published version in our 1-foot-thick binder of original research to Mrs. McCusick, and her tearful appreciation was profoundly rewarding for both of us. And so there ends a summary of my 37-year journey through the law with Nancy Rabasca. And now there's just so much that I will miss. I will miss catching her in the middle of something. She was always in the middle of something. You had to talk at speed while surveying the office for, yes, again, someplace, any place to sit. I will miss her look of being completely aghast when the card catalog revealed that the missing book was not signed out, or worse yet, was signed out but remained unreturned for 4.5 years. I will miss the time spent in her office, the phone ringing constantly, the answering machine beeping away, the Post-it notes overtaking her monitors, the countless boxes of unopened sups accumulating across the floor and steadily rising into the air. I will miss that look when she came around the stacks with eyes big and smile wide, telegraphing that she found it. Whatever it was we were looking for that day, she found it. And the research, I will miss the chase, the shifts, the enthusiasm, and the end goal, not to just get it, but to get it right. Yes, getting it right, the integrity and the diligence. Nancy's ethics and skills, it was Nancy's ethics and skills that made her work consequential, not just for me, but for Maine and the nation. We will all miss that, and I will miss my friend. Thank you.
Good afternoon, all. I am Matt Garrity. I'm a lead law clerk for the law court. And I want to thank Justice Gorman for creating this opportunity for us all to come together and to remember Nancy and sing her praises out loud. something she'd never let us do if she were still here. I worked with Nancy for almost exactly 10 years, first as a law clerk, then as a lawyer representing the state, and then again as the law clerk for the past 6 years. And I want to start by conveying how I described Nancy to new law clerks. As I updated my materials for this term, I found this passage in a memo that I typically wrote for new law clerks. I'm going to read a little bit of it. It said, "Cleaves Law Library is a very helpful resource. My advice is to develop a good working relationship with Nancy Rabasca, the librarian there. Unfortunately, for those of us in Augusta, Nancy does not use the phone." More on that later. But she's very responsive by email. Ask her questions. If you're in Portland, go to Cleaves and introduce yourself and talk to her. She likes to help. She is skilled at what she does, and she cares about getting things right. Continue to work with her as the term progresses. It will make your work better and the court's work better. This is advice that had been given to me when I was first starting out as a law clerk, and it was all obvious to anyone who had worked for the court for a while. It was advice I took seriously, and I'm grateful that I did. It can't be overstated. It really can't be, the positive impact that Nancy personally had on the court's work. As a law librarian, Nancy was absolutely critical to my professional success and the success of others. No one knows more about Maine legal authorities, and there was never a question she could not answer. She was naturally curious, passionate about her work, and she would leave no stone unturned in the hunt for the smallest snippet of legal authority. She would probably dispute this, but I think she had endless patience for lawyers and litigants alike, many of whom can be challenging customers. In 2018, Nancy was the recipient of the John W. Ballou Award, a prestigious award given to those who advance the knowledge and skills of the Maine legal community and, quote, support the public interest in a fair and effective system of justice. In the nomination speech, Justice Gorman pointed out that ours is a vocation based on precedent. Lawyers are only ever as good as their sources. Of course, sources were Nancy's specialty. Nancy was reportedly embarrassed at the award ceremony, humble as she was. She declined to give a speech, anxious for the focus to be on others. Later, she told a friend of mine, "This is the highest honor I'll ever receive." So we could go on and on about Nancy's role as the consummate law librarian. What I had a harder time conveying to new law clerks, and partly I think because I wanted them to experience Nancy on their own, was the unsung, interstitial, almost indescribable but profound role she played in the legal community in Maine. Nancy really took care of people. She opened her doors, the doors of Cleaves, to the public. She treated anyone coming into Cleaves with dignity. She cared deeply about helping people without resources navigate the system, even more deeply than she cared about getting people to pay for their photocopies. And that is saying something. She took care of lawyers trying to figure out their place in the legal landscape. Law clerks, yes, but also practicing attorneys at one crossroads or another. She directly helped more than one law clerk get a job that was a good fit as they started their career in practice. When Nancy started her legal email newsletter, word sort of went around. It was always word of mouth with Nancy. I told some former law clerks, everyone wanted in on it with no hesitation. Get me on that list. We all subscribe to so many of these things, and personally, Nancy's was the only one I actually opened every single time I saw it. I'm going to miss it, and I know I'm not alone in that. You all know this, but Nancy was also a jack of all trades. One minute she'd be debating with you the best dictionary or lamenting some editor's failure to provide a recent update to a secondary source. And then in the next minute, she'd be setting up a Wi-Fi extender at Cleaves or putting in new security features on the computer in the stacks. And she always had her finger on the pulse of the court, no matter, and of the entire legal community. She was a gatherer of information in all respects, and people just told her things. Judge Lopez mentioned one of Nancy's proudest accomplishments, the celebration of Cleaves' 200th anniversary. That happened before I worked with her. At one point, a friend asked her, "How on earth did you get the Chief Justice of the United States Supreme Court to come to Maine and speak at an anniversary event for a local law library?" "I wrote a letter," she said. "Just a letter?" my friend asked, skeptical. And Nancy replied, "It was a very charming letter." And I have always wondered what that letter said. But I have no doubt that it was very charming indeed. Nancy was also a wonderful friend. She was smart, funny, a gifted conversationalist. She was well informed on any topic you could think of. When my wife and I bought an old house in Wiscasset, she gave us a book, of course, about working on old houses, and I still refer to it. She sent gifts to my kids, and she always pestered me to send her cute pictures of them. One thing that made Nancy's death so shocking to me, and I think to all of us, was that she was so incredibly reliable. We would go a couple of months without interacting, especially once I started working in Augusta full-time. And then I'd send her an email with some esoteric legal resource question, and there was the response, right away, every time, exactly what I needed. She was just always there, without exception. And oftentimes, there were no mere research questions. With Nancy, there were a lot of research adventures, research odysseys even. And by the time you got to the other side, you were voyagers who had been through it, and through it together. You had developed some theories, legal ones and otherwise, and you'd become friends. And if you did that enough, you became great friends. Many of us talk to our friends, or even just our librarians, on the phone. Not so with Nancy. When I started working in Augusta, I had been in Portland, and I leaned on Nancy pretty hard to start using the phone. That effort went nowhere. It just wasn't going to happen, and that was just part of who she was. When she took me along one time to help move some books that a lawyer was donating to Cleaves, I tried texting her, and to my surprise, she texted back. After that, we would communicate that way from time to time. I looked back at those messages this morning, and the last ones were about some real estate listings in Bath. This one has a treehouse, I said. And her response was, "You can build your own treehouse in a better neighborhood." And that's just how it was with Nancy. She had opinions she wasn't afraid to share. She had deep natural talent, and she showed up as herself, a thoughtful, sharp-witted friend, and a deeply committed legal researcher and public servant. She is irreplaceable, and we're all better for having known her.
Good afternoon, everybody. My name is Julia Sheridan, and I'm on the Executive Committee of the Board of Directors of Cleaves Law Library. I speak on behalf of the board today in expressing how lucky we were to have Nancy at the helm of the library all these years. She was a careful and attentive custodian of the library and steward of the library. She made its resources available to the bar, the court, and the public, and we all remember her kindness, humor, and intelligence. Not only was she helpful, but she was attuned to all the various dynamics that impacted the library's functioning so that it could be of utmost service to all of us. For myself personally, I'll add, my husband, Chris Devlin, and I joined the Maine Bar in 1989, only 2 years after Nancy took over as librarian at Cleaves. Of course, that era, as you've heard, was pre-internet, and we did our legal research with the books at Cleaves Law Library. Sometimes we'd be there long after closing hours, but before Nancy went home for the night, she made sure we had the resources we needed. She was not just someone who could point us in the direction of the law. She also cared about us as young lawyers and as people. She'd ask how our work lives were going and how our personal lives were going. She really cared. She was supportive and kind, and I'm sure everyone who knew her knows what I mean when I say that she appeared as if she had nothing else to do but check in with you, despite the fact that she was doing the work of about 5 people. Cleaves will not be the same without her. Her humor, her intelligence, her kindness, and her humility. Perhaps it's only in her absence that we'll know everything she did for us and that she meant to us. Thank you, Nancy, for being a dear colleague and a dear friend. We love you and we miss you. Thank you.
Hi, for those of you who don't know me, I'm Matt Pollock, the clerk of the law court. First, I want to say when I first got the call from Julia, actually, about Nancy's passing, I was in shock so much that at the end of the conversation, I actually said to her, let me make sure I have this straight. Nancy passed away today. And she said yes. I actually had a pile of stuff on my desk waiting for her to come get for a patron. Before I go on, I do want to read a few words from a couple of people who have asked me to say something on their behalf. The first is Jim Hangy, who is the representative for Westlaw, which you've heard a little bit about, and has actually worked with Nancy for, I'm guessing, about 20 years or so. So he says, as the longtime Westlaw representative, I'm very saddened by Nancy's passing. I would frequently stop by and talk to her on my many customer visits to Maine. She was always so happy to see me and give feedback on how Westlaw was working for her. And probably on the price, too, I'm guessing. She knew Westlaw much better than myself, and just about anyone for that matter. Nancy was gracious, had time to talk with me, which, personal note here, it's kind of an understatement to say she had time to talk with me with her fantastic smile and laugh. It won't be the same stopping at Cleaves next time I'm there. My deepest condolences to her colleagues, friends, and family. I also got a nice email from the editorial staff at Westlaw, Thomson Reuters, who worked with her often. The retired Superior Court, actually active retired Superior Court Justice Thomas Warren just wanted me to say, Nancy was the best, the most knowledgeable, the most responsive, the most helpful, always with a glint of humor, and the nicest person. I could go on, but that pretty much covers it. So the rest of what I'm going to say is from me, although I don't think I'm going to say anything that anybody would disagree with. I first met Nancy when I moved up to Maine, being a new lawyer, 1993. I was in private practice with my wife in Saginaw County and used Cleaves all the time. I later became the volunteer, I think because I was the new guy in town and the local attorneys convinced me to become the volunteer librarian for the Saginaw County Law Library, back when there was no computerized research and people had to go to their local county libraries, and the state provided libraries in every county, law libraries in every county. again, Nancy was a huge help to me as I worked through the vendors, the bills, what materials, if we had any money left over, we might be able to get, and organizing the library when we had far more books than space. Then, of course, I was an assistant attorney general for a little while. Unfortunately, didn't get to work with Nancy that much in that capacity. I was still working with her on the library stuff, which I'll talk a little bit more about in a minute. But then I got the job here. And since I've been working here, I've worked very closely with Nancy, both getting information from her and giving information from her. And there have been a couple of other people who have commented already how much she would, how much she would work to find resources, and how she always seemed to find the hard-to-find resources. And I was one of her, I don't want to say victim, of trying to get information out of me. And by that I mean nicely, documents she was looking for, records of the Supreme Judicial Court from 50 years before I stepped in. I tried my best. She was, of course, always very nice about it, but what was obviously noticeable was that she was relentless in trying to find those materials. She would not give up. I thought I'd be rid of her after the third no, it wasn't there, when she would say, well, have you tried maybe here? Can you ask this person? And that went for legal documents, for portraits, photographs, paintings of old lawyers from long ago. She's actually very responsible for the portraits of the Supreme Judicial Court justices from the beginning to the present, up on the third floor. And she was, as some have mentioned, really the expert in the history of Maine courts and its people. One viewpoint I guess I can share that you maybe won't get or haven't gotten from the other speakers is her work with other Maine libraries, both law libraries and some public libraries. As I mentioned, when I was with the Saginaw County Law Library, she was extraordinarily helpful to me. Very recently, she kind of helped reset up the Penobscot County Law Library. They kind of went without a librarian for a while. They have a very part-time staff there, but the Penobscot County Bar Association had a new president. They decided to really get moving to kind of reinvigorate that library, and they relied on advice from Nancy quite a bit. The Maine legislature actually asked her to sit on a panel to interview a new director of the Maine State Law and Legislative Reference Library, back when longtime librarian Lynn Randall retired. I actually interviewed for that position. As Justice Gorman mentioned, I am a librarian also, at least in that I have a library degree. And I interviewed for that position. So I was kind of happy to see a friendly face among the legislators in the interview panel when I got there. And Nancy was very complimentary to me afterwards about how the interview went. I didn't get the job, which I never forgave her for, but she was very nice about how the interview went. As you know, the Maine judicial branch relies heavily on her, but not just for actually doing the research, but for determining how we should do research. And by that I mean she helps us find books, select books to buy sometimes, talk to me about publishers and what was out there. And she sat on every team that I've been on since I started here when it came time to select, to put out bids for Westlaw or Lexis as our
legal research service. And again, she was very helpful, spent a lot of time on it with us, and told us what was wrong with each service, which was very helpful. And I think you've heard the help that she gave to the executive branch also. So Nancy has helped, right, every branch of government, every lawyer. And I do want to also point out, some people have mentioned it, but from my standpoint at least, the help she gave to unrepresented parties is absolutely invaluable. I mean, we would be able to send people up to her if they had questions. The trial court clerks have told me they did the same thing. They asked me recently if there was a copier anywhere that people could use when they came in with just their one copy of a filing, because they used to send people up to Cleaves, and unfortunately that hasn't been available to the public since then. But she may have done a little more than technically she was supposed to with some pro se parties. Fortunately, she was never prosecuted for the unauthorized practice of law. But she really was, and everyone who went up there and then came back down or whatever told us how helpful she was. And that is, as you all know, very underserved population in Maine, and at least we were able to offer her that, offer the parties that for assistance. So I think I will end. Just want to say that, to me anyway, Nancy passed the ultimate test of a human being, and that the world was a much better place for having had her in it, and it just won't be the same without her. Thank you.
I can't add to everything everybody said. I think it's very clear the esteem in which Nancy was held by the judicial branch and by Maine's legal community. My chambers are in Augusta, so I did not interact with Nancy on a regular basis the way some others have. But let me just say on a personal note, we have a photograph and a presentation, and I want to say something about this photograph, which came from the family. And that is that this is actually the Nancy I remember, because when I'm down here for oral arguments, afterwards, if I passed through the third floor, she would say, with a gleam in her eye and a chortle, "Did you hear what that person said?" She loved it. Ooh, that was a good one. So, the reason we have this photograph is as a presentation to the library and to the family. We wanted to make sure there was something tangible that measures the esteem in which she was held by the judicial branch. Appropriately, I asked a law clerk to write something. And Rose, are you here somewhere? There you are, way in the back. Rose, who's been with us for over 20 years, wrote something for me to consider, to frame. Now, as Matt knows, having been working with me for a while now, I completely rewrite whatever my law clerk writes. I didn't change a word. So although this is signed by me on behalf of the court, these are the words of our law clerks. During her nearly 40 years as librarian, Nancy Rabasca provided unparalleled research assistance to members of the public and generations of judges, lawyers, and law clerks. With her broad and deep knowledge of legal and historical resources, her boundless curiosity and determination, Nancy enriched the legal community through her work and made profound contributions to the development of the law in Maine. She did so without sacrificing her sense of humor or her love of family, nature, and the arts. Signed, Chief Justice Valerie Stanfield for the Maine Supreme Judicial Court. We would ask that this, we're presenting it really to the Cleaves family and hope that it will be hung up in the Cleaves Law Library. And we also have one for the family, so we made two to keep as a keepsake. Thank you.
That completes the presentation for the day. We have a reception upstairs with cookies, which, when I put them out, I thought there were too many. Now I think there might be too few. But we have cookies and sparkling water upstairs, and you're all invited. It's up in the hallway of the 3rd floor. If you go up either the elevator here or these stairs and go all the way down towards the other elevators, there are tables and everything should be out there. Please come upstairs and mingle, and you can meet the family. They'll be up there and be happy to talk with all of you. But we are adjourned. Thank you.